This audio case is brought to you by Laudio. Perlman v. Feldmann, 1955. This is a derivative action brought by minority stockholders of Newport Steel Corporation to compel accounting for and restitution of allegedly illegal gains which accrue to defendants as a result of the sale in August 1950 of their controlling interest in the corporation. The principal defendant, C. Russell Feldmann, who represented and acted for the others, members of his family, was at that time not only the dominant stockholder, but also the chairman of the board of directors and the president of the corporation. Newport, an Indiana corporation, operated mills for the production of steel sheets for sale to manufacturers of steel products, first at Newport, Kentucky, and later also at other places in Kentucky and Ohio. The buyers, a syndicate organized as Willport Company, a Delaware corporation, consisted of end users of steel who were interested in securing a source of supply in a market becoming ever tighter in the Korean War. Plaintiffs contend that the consideration paid for the stock included compensation for the sale of a corporate asset, a power held in trust for the corporation by Feldmann as its fiduciary. This power was the ability to control the allocation of the corporate product in a time of short supply through the control of the board of directors, and it was effectively transferred in this sale by having Feldmann procure the resignation of his own board and the election of Willport's nominees immediately upon consummation of the sale. The present action represents the consolidation of 3 pending stockholders' actions in which yet another stockholder has been permitted to intervene. Jurisdiction below was based upon the diverse citizenship of the parties. Plaintiffs argue here, as they did in the court below, that in the situation here disclosed, the vendors must account to the non-participating minority stockholders for that share of their profit which is attributable to the sale of the corporate power. Judge Hinks denied the validity of the premise, holding that the rights involved in the sale were only those normally incident to the possession of a controlling block of shares, with which a dominant stockholder, in the absence of fraud or foreseeable looting, was entitled to deal according to his own best interests. Furthermore, he held that plaintiffs had failed to satisfy their burden of proving that the sales price was not a fair price for the stock per se. Plaintiffs appealed from these rulings of law, which resulted in the dismissal of their complaint. The essential facts found by the trial judge are not in dispute. Newport was a relative newcomer in the steel industry with predominantly old installations which were in the process of being supplemented by more modern facilities. Except in times of extreme shortage, Newport was not in a position to compete profitably with other steel mills for customers not in its immediate geographical area. Willport, the purchasing syndicate, consisted of geographically remote end users of steel who were interested in buying more steel from Newport than they had been able to obtain during recent periods of tight supply. The price of $20 per share was found by Judge Hinks to be a fair one for a control block of stock, although the over-the-counter market price had not exceeded $12 and the book value per share was $17.03. But this finding was limited by Judge Hinks' statement that, quote, "What value the block would have had if shorn of its appurtenant power to control distribution of the corporate product, the evidence does not show." End quote. It was also conditioned by his earlier ruling that the burden was on plaintiffs to prove a lesser value for the stock. Both as a director and as dominant stockholder, Feldmann stood in a fiduciary relationship to the corporation and to the minority stockholders as beneficiaries thereof. His fiduciary obligation must, in the first instance, be measured by the law of Indiana, the state of incorporation of Newport. Although there is no Indiana case directly in point, the most closely analogous one emphasizes the close scrutiny to which Indiana subjects the conduct of fiduciaries when personal benefit may stand in the way of fulfillment of trust obligations. In Schemmel v. Hill, 1930, Justice McMahon said, quote, "Directors of a business corporation may act in a strictly fiduciary capacity. Their office is a trust. When a director deals with his corporation, his acts will be closely scrutinized. Directors of a corporation are its agents, and they are governed by the rules of law applicable to other agents, and, as between themselves and their principal, the rules relating to honesty and fair dealing in the management of the affairs of their principal are applicable. They must not, in any degree, allow their official conduct to be swayed by their private interest, which must yield to official duty. In a transaction between a director and his corporation, where he acts for himself and his principal at the same time in a matter connected with the relation between them, it is presumed, where he is thus potential on both sides of the contract, that self-interest will overcome his fidelity to his principal, to his own benefit, and to his principal's hurt." End quote. And the judge added, quote, "Absolute and most scrupulous good faith is the very essence of a director's obligation to his corporation. The first principal duty arising from his official relation is to act in all things of trust wholly for the benefit of his corporation." End quote. In Indiana, then, as elsewhere, the responsibility of the fiduciary is not limited to a proper regard for the tangible balance sheet assets of the corporation, but includes the dedication of his uncorrupted business judgment for the sole benefit of the corporation and any dealings which may adversely affect it. Although the Indiana case is particularly relevant to Feldman as a director, the same rule should apply to his fiduciary duties as majority stockholder, for in that capacity he chooses and controls the directors, and thus is held to have assumed their liability. This, therefore, is the standard to which Feldman was by law required to conform in his activities here under scrutiny. It is true, as defendants have been at pains to point out, that this is not the ordinary case of breach of fiduciary duty. We have here no fraud, no misuse of confidential information, no outright looting of a helpless corporation. But on the other hand, we do not find compliance with that high standard which we have just stated, and which we and other courts have come to expect and demand of corporate fiduciaries. In the oft-quoted words of Judge Cardozo, quote, "Many forms of conduct permissible in a workaday world for those acting at arm's length are forbidden to those bound by fiduciary ties. A trustee is held to something stricter than the morals of the marketplace. Not honesty alone, but the punctilio of an honor the most sensitive, is then the standard of behavior. As to this, there has developed a tradition that is unbending and inveterate. Uncompromising rigidity has been the attitude of courts of equity when petitioned to undermine the rule of undivided loyalty by the disintegrating erosion of particular exceptions." End quote. The actions of defendants in siphoning off for personal gain corporate advantages to be derived from a favorable market situation do not betoken the necessary undivided loyalty owed by the fiduciary to his principal. The corporate opportunities of whose misappropriation the minority stockholders complain need not have been an absolute certainty in order to support this action against Feldman. If there was possibility of corporate gain, they are entitled to recover. In Young v. Higbee Company, 1945, two stockholders appealing the confirmation of a plan of bankruptcy reorganization were held liable for profits received for the sale of their stock pending determination of the validity of the appeal. They were held accountable for the excess of the price of their stock over its normal price, even though there was no indication that the appeal could have succeeded on substantive grounds. And in Irving Trust Company v. Deutsch, 1934, an accounting was required of corporate directors who bought stock for themselves for corporate use, even though there was an affirmative showing that the corporation did not have the finances itself to acquire the stock. Judge Swan, speaking for the court, pointed out that, quote, "The defendant's argument, contrary to Wing v. Dillingham, 1917, that the equitable rule that fiduciaries should not be permitted to assume a position in which their individual interests might be in conflict with those of the corporation can have no application where the corporation is unable to undertake the venture is not convincing. If directors are permitted to justify their conduct on such a theory, there will be a temptation to refrain from exerting their strongest efforts on behalf of the corporation, since, If it does not meet the obligations, an opportunity of profit will be open to them personally." End quote. This rationale is equally appropriate to consideration of the benefits which Newport might have derived from the steel shortage. In the past, Newport had used and profited by its market leverage by operation of what the industry had come to call the Feldmann plan. This consisted of securing interest-free advances from prospective purchasers of steel in return for firm commitments to them from future production. The funds thus acquired were used to finance improvements in existing plants and to acquire new installations. In the summer of 1950, Newport had been negotiating for cold rolling facilities, which it needed for a more fully integrated operation and a more marketable product, and Feldman planned funds might well have been used toward this end. Further, as plaintiffs alternatively suggest, Newport might have used the period of short supply to build up patronage in the geographical area in which it could compete profitably even when steel was more abundant. Either of these opportunities was Newport's, to be used to its advantage only. Only if defendants had been able to negate completely any possibility of gain by Newport could they have prevailed. It is true that a trial court finding states, quote, "Whether or not, in August 1950, Newport's position was such that it could have entered into Feldman plan-type transactions to procure funds and financing for the further expansion and integration of its steel facilities, and whether such expansion would have been desirable for Newport, the evidence does not show." End quote. This, however, cannot avail the defendants, who, contrary to the ruling below, had the burden of proof on this issue, since fiduciaries always have the burden of proof in establishing the fairness of their dealings with trust property. Defendants seek to categorize the corporate opportunities which might have accrued to Newport as too unethical to warrant further consideration. It is true that reputable steel producers were not participating in the gray market brought about by the Korean War, and were refraining from advancing their prices, although to do so would not have been illegal. But Feldman plan transactions were not considered within this self-imposed interdiction. The trial court found that around the time of the Feldman sale, Jones and Laughlin Steel Corporation, Republic Steel Company, and Pittsburgh Steel Corporation were all participating in such arrangements. In any event, it ill becomes the defendants to disparage as unethical the market advantages from which they themselves reaped rich benefits. We do not mean to suggest that a majority stockholder cannot dispose of his controlling block of stock to outsiders without having to account to his corporation for profits, or even never do this with impunity when the buyer is an interested customer, actual or potential, for the corporation's product. But when the sale necessarily results in a sacrifice of this element of corporate goodwill and consequent unusual profit to the fiduciary who has caused the sacrifice, he should account for his gains. So, in a time of market shortage where a call on a corporation's product commands an unusually large premium in one form or another, we think it sound law that a fiduciary may not appropriate to himself the value of this premium. Such personal gain at the expense of his co-venturers seems particularly reprehensible when made by the trusted president and director of his company. In this case, the violation of duty seems to be all the clearer because of this triple role in which Feldman appears, though we are unwilling to say, and are not to be understood as saying, that we should accept a lesser obligation for any one of his roles alone. Hence, to the extent that the price received by Feldman and his co-defendants included such a bonus, he is accountable to the minority stockholders who sue here. And plaintiffs, as they contend, are entitled to a recovery in their own right, instead of in right of the corporation, as in the usual derivative actions, since neither Willport nor their successors in interest should share in any judgment which may be rendered. Defendants cannot well object to this form of recovery, since the only alternative, recovery for the corporation as a whole, would subject them to a greater total liability. The case will therefore be remanded to the district court for determination of the question expressly left open below, namely, the value of the defendant's stock without the appurtenant control over the corporation's output of steel. We reiterate that on this issue, as on all others relating to a breach of fiduciary duty, the burden of proof must rest on the defendants. Judgment should go to these plaintiffs and those whom they represent for any premium value so shown to the extent of their respective stock interests. The judgment is therefore reversed and the action remanded for further proceedings pursuant to this opinion. Dissent. Circuit Judge Swan dissenting. With the general principles enunciated in the majority opinion as to the duties of fiduciaries, I am, of course, in thorough accord. But, as Mr. Justice Frankfurter stated in Securities and Exchange Commissioners v. Chenery Corporations, 1943, quote, "To say that a man is a fiduciary only begins analysis. It gives direction to further inquiry. To whom is he a fiduciary? What obligations does he owe as a fiduciary? In what respect has he failed to discharge these obligations?" End quote. My brother's opinion does not specify precisely what fiduciary duty Feldman is held to have violated, or whether it was a duty imposed upon him as the dominant stockholder or as a director of Newport. Without such specification, I think that both the legal profession and the business world will find the decision confusing and will be unable to foretell the extent of its impact upon customary practices in the sale of stock. The power to control the management of a corporation, that is, to elect directors to manage its affairs, is an inseparable incident to the ownership of a majority of its stock, or sometimes, as in the present instance, to the ownership of enough shares, less than a majority, to control an election. Conceitedly, a majority or dominant shareholder is ordinarily privileged to sell his stock at the best price obtainable from the purchaser. In doing so, he acts on his own behalf, not as an agent of the corporation. If he knows or has reason to believe that the purchaser intends to exercise to the detriment of the corporation the power of management acquired by the purchase, such knowledge or reasonable suspicion will terminate the dominant shareholder's privilege to sell and will create a duty not to transfer the power of management to such purchaser. The duty seems to me to resemble the obligation which everyone is under not to assist another to commit a tort, rather than the obligation of a fiduciary. But whatever the nature of the duty, a violation of it will subject the violator to liability for damages sustained by the corporation. Judge Hinks found that Feldman had no reason to think that Willport would use the power of management it would acquire by the purchase to injure Newport, and there was no proof that it was ever so used. Feldman did know, it is true, that the reason Willport wanted the stock was to put in a board of directors who would be likely to permit Willport's members to purchase more of Newport's steel than they might otherwise be able to get. But there is nothing illegal in a dominant shareholder purchasing from his own corporation at the same prices it offers to other customers. That is what the members of Willport did, and there is no proof that Newport suffered any detriment therefrom. My brothers say that, quote, "The consideration paid for the stock included compensation for the sale of a corporate asset," end quote, which they describe as, quote, "the ability to control the allocation of the corporate product in a time of short supply through control of the board of directors, and it was effectively transferred in this sale by having Feldman procure the resignation of his own board and the election of Willport's nominees immediately upon consummation of the sale," end quote. The implications of this are not clear to me. If it means that when market conditions are such as to induce users of a corporation's product to wish to buy a controlling block of stock in order to be able to purchase part of the corporation's output at the same mill list prices as are offered to other customers, the dominant stockholder is under a fiduciary not to sell his stock, I cannot agree. For reasons already stated, in my opinion, Feldman was not proved to be under any fiduciary duty as a stockholder not to sell the stock he controlled. Feldman was also a director of Newport. Perhaps the quoted statement means that, as a director, he violated his fiduciary duty in voting to elect Willport's nominees to fill the vacancies created by the resignations of the former directors of Newport. As a director, Feldmann was under a fiduciary duty to use an honest judgment in acting on the corporation's behalf. A director is privileged to resign, but so long as he remains a director, he must be faithful to his fiduciary duties and must not make a personal gain from performing them. Consequently, if the price paid for Feldmann's stock included a payment for voting to elect the new directors, he must account to the corporation for such payment, even though he honestly believed that the men he voted to elect were well qualified to serve as directors. He cannot take pay for performing his fiduciary duty. There is no suggestion that he did so unless the price paid for his stock was more than its value. So it seems to me that decision must turn on whether finding 120 and conclusion 5 of the district judge are supportable on the evidence. They are set out in the margin. Judge Hanks went into the matter of valuation of the stock with his customary care and thoroughness. He made no error of law in applying the principles relating to valuation of stock. Conceitedly, a controlling block of stock has greater sale value than a small lot. While the spread between $10 per share for small lots and $20 per share for the controlling block seems rather extraordinarily wide, the $20 valuation was supported by the expert testimony of Dr. Badger, whom the district judge said he could not find to be wrong. I see no justification for upsetting the valuation as clearly erroneous. Nor can I agree with my brothers that the $20 valuation was limited by the last sentence in finding 120. The controlling block cannot by any possibility be shorn of its appurtenant power to elect directors and through them to control distribution of the corporate product. It is this appurtenant power which gives the controlling block its value as such block. What evidence could be adduced to show the value of the block, if shorn of such appurtenant power, I cannot conceive, for it cannot be shorn of it. The opinion also asserts that the burden of proving a lesser value than $20 per share was not upon the plaintiffs, but the burden was upon the defendants to prove that the stock was worth that value. Assuming that this might be true as to the defendants who were directors of Newport, they did show it, unless finding 120 be set aside. Furthermore, not all the defendants were directors. Upon what theory the plaintiffs should be relieved from the burden of proof as to defendants who are not directors, the opinion does not explain. The final conclusion of my brothers is that the plaintiffs are entitled to recover in their own right instead of in the right of the corporation. This appears to be completely inconsistent with the theory advanced at the outset of the opinion, namely, that the price of the stock, quote, included compensation for the sale of a corporate asset, end quote. If a corporate asset was sold, surely the corporation should recover the compensation received for it by the defendants. Moreover, if the plaintiffs were suing in their own right, Newport was not a proper party. The case of Southern Pacific Company v. Bogert, 1919, relied upon as authority for the conclusion that the plaintiffs are entitled to recover in their own right, relates to a situation so different that the decision appears to me to be an apposite. I would affirm the judgment on appeal. For more audio cases, visit us at laudioforlisteners.com. Follow us on Instagram and Facebook, and subscribe to our YouTube channel.